Welcome everybody today. Thank you for joining. Today I have Mark Kadeski with me, which I'm really excited to be interviewing, and it's an Ask Mark thing with Mark today. For those who don't know Mark, he was my broker of record for a while. Actually, sorry, he was my broker manager for a while, and he has been in the business since 1994, a broker since 2009. He was a productivity coach, team leader, broker of record, taught at OREA, and also a current TREB Professional Standards Hearing Committee. So I'll just give it away to Mark. Just tell us a little bit about what we're going to be talking about today.
All right. Thanks a lot, Rob. Thanks for having me. Today I've been getting quite a few inquiries about this particular topic. There are many people who have been asking me what happens, whether they're on the listing side or on the cooperating side, what happens if the buyer just doesn't bring the deposit? So I wanted to talk about that today because I think there's some things are going to come out that surprise many of you. Just to let you know, I would like to make this as interactive as possible. So if you have any comments or questions, please feel free to chime in the comment box there, or if you'd like to ask a question sort of face-to-face, we can do that as well. Josh, maybe you can explain how that's going to work. But I do want to let you know that if you're going to appear in person on screen, that this is being recorded, and I may end up putting this on my website. So, and it may appear in other places as well. So if you don't want to appear anywhere, then maybe the anonymous comment box is the place for you to do that. And if you don't mind showing your face, then by all means, please come on in and let's chat face to face. Josh, can you just explain how that's going to work? Josh, our producer.
Yeah, so I just put the link in our comments there. So if you guys want to chime in, by all means, just click on that link. You can log in, and then I can add you onto the stream. You can ask some questions and everything. If you don't want to, again, you can put the comments in the chat, and then again, I'll forward it off to them. They can see all that for you.
All right, thanks a lot, producer Josh.
Thank you.
How many of you are under the impression that if your buyer, let's say you're in a multiple offer, there were 15 offers, the deposit, you're going to bring it tomorrow, your buyer's going to bring it tomorrow, and then you get a call at 10 o'clock from your buyer who has woken up out of his ether, gave his head a shake, and said, "What the hell have I done? I don't want to proceed. I'm just not going to bring the deposit," and we're done. How many of you are feeling that, yep, that's fine, no deposit, no deal? Rob, I can't see any comments here, so.
Yeah. So I can personally say that it's happened to me a few times, and the agents on the other side, I was representing the sellers, and the agents on the other side just said, "Oh, you know what? My clients in multiple offers changed their mind, and I'm really sorry about that, but they don't want to go through. But you had a lot of offers, so why don't you just take one of the other offers?"
And what is okay? And this happens quite frequently, as we're all painfully aware. Now, how many, Rob? What's your understanding with respect to the purpose of the deposit?
The deposit is, put in trust first of all, right? Mm-hmm. And it's going to be showing consideration and good faith for the accepted offer that is taking place.
All right. So you mentioned two things there, and they're not the same. You mentioned consideration and you mentioned good faith.
Right.
So your half of that is right. The deposit actually is a show of good faith by the buyer. It is not, however, consideration. And I know that many of us are under the impression that the deposit is consideration for the offer. It's not. So let's go back to what consideration is. Consideration is a promise for a promise, an act in exchange for an act, or an act in exchange for a promise. When you have the agreement of purchase and sale, the consideration is, you promise to sell me your house, I promise to pay you the money. That's consideration. It isn't the deposit. All right, so that's number one. Number two, on the signing page of the offer, what is What's important, Rob, on the signing page of the offer as it relates to consideration? Do you know?
What is important on the offer as it relates to consideration?
On the signing page, I'll give you a hint. It's on the signing
Well,
page.
I think you're talking about the signing under seal.
I am talking about the signing under seal. Do you know what the purpose of the seal is, or how it relates to consideration?
You're basically sealing that. I think originally they used original actual seals to say that this offer is accepted and confirmed, and you're signing under seal, so you agree to the terms of it. So that is it. Would you say that is the consideration in there, or
Not quite. As a matter of fact, the seal negates the necessity for consideration. So even if there was no consideration, which there is, as we've just discussed, it's a promise for a promise, the fact that it's been signed under seal by both parties means that no consideration is required. Ergo, the deposit, which has nothing to do with really consideration anyway, if that's your argument, that if there's no deposit, there's no consideration, that flies out the window. Okay, so it's not the case that if there's no deposit, there's no consideration. Not the case. Okay, so let's start there. So if we move forward, and let's go back also as to when the deposit must be delivered. Under normal circumstances, does anybody know, you should know, when the deposit must be delivered? If nothing has been added to the Schedule A, when does it have to be delivered to the listing brokerage?
I guess I'm your student today, and I'm going to say it's before 24 hours of the accepted offer if you don't change the pre-printed clauses in the arrears.
Okay, so let's say, Rob, that we have struck out the word negotiable on the first page of the offer on the deposit line, and we've put certified, and the buyer and seller have both initialed, so the buyer agrees to deliver a certified deposit check or a bank draft. And we did our deal. The confirmation of acceptance is done at 10 p.m. on Saturday evening.
Mm-hmm.
When does the deposit need to be delivered to the listing brokerage?
Before 10 p.m. on Sunday. Which could be a problem, right?
It could, in fact, be a problem. The problem could be that, well, banks are closed. And I know some of you are going to say, well, not all banks are closed. And that's true. Not all of them are, but many of them are. So good luck getting a deposit in time to be delivered at 10 p.m. by 10 p.m. on Sunday. Note that it does not say 24 banking hours. It just says 24 hours. Okay. And that went into effect because of a case that happened a long time ago called the Loblaws case. And we'll talk a little bit more about that in a minute. Okay. So for purposes of our discussion here, the deposit's got to be delivered within 24 hours. Otherwise, it's late. And as a matter of fact, in that Loblaws case, the judge said 10 minutes late is late. Okay, so let's discuss now what happens if the deposit is delivered on Monday at 10:30 in the morning instead of, in our example, by Sunday at 10 p.m. What could happen?
That's a great question. That's why we have you here. I'm going to say the sellers would have the right to accept it, but they don't have to accept it. I think that's what you're referring to on the Loblaws case.
Yeah.
Right?
All right. So if we back up for a minute to our original question, what happens if the deposit is not delivered? We've already established that, in fact, the deal is still potentially going on, but what we have is a breach of contract by the buyer. It's breach of contract. Okay, plain and simple. Now, under most circumstances, I think what many of you would have done at that time, if you're on the listing side and you get a call from the cooperating agent to say, you know what, my buyer's just not bringing the deposit, move on. Some of you will just say, okay, we'll just move on and relist the property. And others of you will say, well, we got to get a mutual lease because I don't want, the possibility of the buyer coming back later and firming up and creating a problem and all that sort of stuff. I'm going to tell you that signing a mutual lease is putting your seller at a disadvantage. And here's why. By the way, do we have any questions up to this point? Does anybody disagree? Anybody have any? Hi, Waleed. You have a question?
Thank you, Mark. So if having something signed under seal negates the
Requirement for consideration. Yeah.
does that mean we can have deposits of $0 now instead of the $2 requirement that I understood was necessary?
You can have a $0. You can have $0 for deposit. I think your seller would be foolish to accept such an offer.
I always thought there was a minimum of $2.
No, because you're thinking, for good consideration of a dollar that you often see in contracts, maybe you're coming back to that. But as we've established, the deposit is not consideration.
Very good.
Okay. So yeah, you can, but remember, folks, if you're on the listing side, you got to be out of your minds to advise your seller clients to accept an offer for no deposit or for something really, really puny. And we're going to talk about why that is right now. Okay.
Thank you.
Any other questions? All right, good. So we were talking about a mutual lease and the idea that to have your seller sign a mutual lease puts your seller potentially at a disadvantage. And here is why. Let's assume for the moment the buyer makes an offer of, I don't know, $1 million and it's accepted, and there is a $50,000 deposit, and that deposit is not brought. Rather than sign a mutual lease, since the buyer is in breach of contract, you could immediately put the property back on the market if the deposit's not brought and see how it transpires. Even if you get more money, if you sell it for 1.1, it's possible that your seller could still go after buyer A, the one who did not bring the $50,000 deposit. Your seller still may be able to go after the seller. Your seller still may be able to go after buyer A for that $50,000. If they end up selling it for less than $1 million, they certainly could go after the buyer for that $50,000, even after they've sold it to somebody else. Now, we also said a minute ago that late is late. So if the check was dropped off half an hour late, because the buyer's in breach of contract, that makes the deal voidable by the seller. So the seller has an option. I could continue here if I want, but I also don't have to. I can sell it to somebody else. So if you think you've got backup offers, because you get calls from all the other agents who submitted offers, if something happens with this one, let me know and I'll resubmit. It's possible that you could sell it to somebody else and get more money, but you also may be able to collect the deposit from buyer A who didn't bring in the first place. The same thing happens if it's late. So if it's late, what you want to do is call up your seller's lawyer. Have the lawyer send a letter to the buyer's lawyer immediately that says you are in breach of contract. Remember, even if it's late, they're in breach. 10 minutes late is still late. They're in breach. Okay, so the seller's lawyer is going to put the buyer's lawyer on notice. You're in breach of contract. We're going to put the property back on the market. We're going to mitigate, because that's what we're required to do, mitigate our damages. And we're going to see what happens, but we reserve the right to claim the deposit later on. All right, so it's going to sit in trust if it's already been accepted by your brokerage. They told you it's already there, so you can't send it back. So that could happen. All right, any questions on that so far? Waleed.
Thank you. It's actually not my question. Somebody just sent me a text. They're watching on the live stream.
Mm-hmm.
So let's say you have offer number one gets accepted, deposit is made. Then somebody comes in and submits a backup offer,
Mm-hmm.
which also gets accepted. Deposit is not made. Does that change anything that you just said with respect to buyer number 2?
So you accepted offer number 1, and then you also accepted offer number 2?
Because offer number 1 is conditional.
That's a mistake that the seller made, I think, because they potentially have sold their one property to 2 buyers. No good's going to come of it for them.
Interesting. Are there any protections a seller could put in place?
Yeah, you could accept the second offer conditional upon being released from a previous agreement.
Okay. So
But
let's say
that's
that's there.
Okay, so if that's there, then that's there. So so now
But
what's
deposit number 2 doesn't come in.
Mm-hmm.
And let's say, I don't know what the reason of it, but let's say deposit number 2 doesn't come in.
Mm-hmm.
So how could it play out if the first offer gets accepted and goes firm?
Mm-hmm.
Or if the first offer doesn't get accepted and doesn't go firm, and then buyer number 2 is there without having to make a deposit.
Okay. Well, if offer number 1 gets accepted, then that condition in offer number 2, which is we're only this, we accept this conditional upon being released from a previous agreement, that does not get fulfilled because they didn't get released from the previous agreement because buyer 1 firmed up.
Right.
So offer number 2 is no more, is finito. If offer number 1 does not firm up, okay, so it was conditional, it didn't firm up, you got offer number 2, the deposit was not brought, then yeah, same thing applies for offer number 2.
Now, while we're waiting to hear from offer number 1, you still feel it's a mistake not to sign a mutual release with offer number 2? While we are waiting for offer number 1 to go firm, offer number 2 says, you know what, our buyer became ill, we'd like a mutual release. And we haven't sent the deposit, so it doesn't matter anyway. And you told me offer number 1 is looking solid. Please release us. You still feel that's a mistake on the seller's part?
To sign the release? Well, this is a question really for a lawyer at this point because I don't know. I'm very reluctant. If I've already got an accepted offer, I'd be very reluctant to get my seller involved in accepting a second offer until I knew what was going on with the first one. I mean, if I got a call from agent number 1 saying, the possibility is extremely unlikely that we're going to, or the odds are, it's just not very likely that we're going to firm up, then I'll put them on notice and just tell them to have their buyer ready. But I don't know that I would accept it until I actually, till the first one was dealt with. It just gets messy.
And dealt with, you mean we know it's not firming up, but the mutual release has yet to be signed?
Well, if they didn't waive their conditions in time, then the deal is dead anyway, and the mutual release really is just to make sure that they get their deposit back. But it's a dead deal if the conditions were not waived in time.
Okay, so mutual release in this case benefits the buyer to get their deposit back, not so much the seller. Seller can
buyer A. I'm talking
buyer
about
A.
now. Buyer A.
Okay. Hey, Mark, a question just came in on my chat here. What happens if there's a buyer and they have a conditional offer, okay, and they send an amendment that they want to amend, the price or something in the agreement to firm up? The seller doesn't sign it. Now they've actually sent another thing. Can they still firm up on that deal?
I want to make sure I understand. I think what you're asking me is, all right, we've got an offer. The deposit's been delivered.
Yeah.
The conditions, it's financing and inspection.
Sure.
The financing's okay, but they do the inspection and the furnace is fakaked and it needs a couple of other things and they want, I don't know, a $10,000 abatement.
Right.
Is this
That's the scenario? Yeah. If
right.
they send in an amendment for a price reduction or something else, and then after they want to still firm up, are they still able to firm up?
If the seller doesn't accept the amendment doesn't exist. So 100% they can still firm up.
Okay.
Now, there was, there have been some interesting cases around that, but yeah, and this is why, folks, if you're Fariel, I see your question. Okay, so I'll come back to that. So folks, if you are going to do an amendment, it's imperative, remember that there's an irrevocable date and time on the amendment. It's imperative that the irrevocable on the amendment is well in advance of the condition expiry date and time. Because if the amendment gets accepted after the conditions expire, your deal was dead at the time the conditions expired. So if you got your condition until 10 p.m. on Sunday and you want to send an amendment, I wouldn't remove the condition and do the $10,000 abatement on the same amendment. I would only do the $10,000 amendment, $10,000 abatement on the amendment, get that dealt with, then do the notice of fulfillment or the waiver, as the case may be, depending on what condition we're talking about. But if you got a 10 o'clock drop dead time for the condition, then the amendment irrevocable shouldn't be really any later than about 8 o'clock, because you want to make sure that your buyer still has enough time to send a notice of fulfillment or a waiver if the seller says, no, I don't agree. Or gives you enough time to negotiate a little bit back and forth if that's where it's going.
Awesome. So they can accept the original agreement in that circumstance.
Well, you still have the original agreement, because like I said, remember, an amendment has to be signed by both parties. So it's only signed by one. There's no amendment.
Right. You know what? They're actually saying, what if you countered the offer and then after wanted to accept the original offer back? So the buyer in this circumstances countered an offer and then decided to accept the original offer before the original irrevocable.
Well, the amendment, remember, is irrevocable now. If the seller signs back the amendment, remember that the amendment is irrevocable by the seller. So you can't, once you've sent it, you can't revoke it until that irrevocable is finished. So
Okay.
you can accept it after the irrevocable is finished if the buyer doesn't accept the counteroffer on the amendment. Okay, so remember, the amendment's got to be signed by both sides in order for it to have any force or effect. There was a question here that I don't know if anybody saw. Can we touch again on what happens? Thanks, Fariel. Can you please touch again on what happens if the property gets sold on a Saturday and deposit to be made within 24 hours? Since the next day is Sunday and a holiday, the buyer can submit the offer on Monday. I think you mean the buyer can submit the deposit on Monday, right? Well, late is late. So let's talk about what kind of a solution could we have if we know that our offer is being accepted and dealt, negotiated, and it's going to be done Saturday night, late at night, and we're not going to get a certified check or a draft tomorrow because the bank's closed. What could we do to solve that problem? Waleed.
Right, banking hours. Within 24 hours of banking hours.
Well, you could do that, although that gets a little bit hairy as well, because as we've discussed, some banks are open on Sunday. So really, what does that mean? So where on the first page, we can do this one of two ways. We can either on first page of the agreement in the deposit section where it says, for purposes of this agreement, upon acceptance shall mean within 24 hours of acceptance of this agreement. We can cross out 24 and put 48 or 72, get both parties to initial. Now we're good. Or on the Schedule A, we can say the buyer shall deliver the deposit by not later than 6 p.m. on Monday, Tuesday, whatever it is. Okay, so one of those two ways. But this happens a lot, folks, where we fall asleep at the switch. And in fact, what we're doing is putting our own buyers into breach of contract. They don't know this stuff. We're supposed to know, and we're supposed to protect them. So in order to ensure that we don't put our buyers into breach of contract, you better make sure that they can live up to whatever it is you're asking them to live up to, like delivering the deposit within 24 hours. If they can't, you have to make it so that they can live up to what the contract says they have to do.
That's a good point, Mark. I just wanted to add, I think, for my team especially, maybe having a clause in our Schedule A that says, the next banking day, or and specify it as a, Monday to Friday kind of thing might be a good idea to put in our contracts, because we've had a couple circumstances where we're back and forth, and then, you start negotiating on a Thursday, and then all of a sudden it's Saturday night, right? So I think that might be a good thing, because it's happened to me, and one of the agents tried to use that because we couldn't get in on a Sunday when we said, hey, we tried, you guys were closed. So the sellers wanted to back out, right?
Yeah, and
they
if the
tried.
deposit wasn't delivered, they could.
Yeah, so our lawyers on for our buyers,
Potentially.
they were kind of like, I'd like to see them back out when the brokerage wasn't available to be open. The
Yeah.
agent said at the time, she's like, well, that's why I said I'll meet with you, but it just anyways, the deal went through, it was okay, so that was a good thing. So do you think that, like, having a clause in there, like as a standard thing, obviously anything in the schedule will replace the pre-printed clauses, correct?
Yes, that's true. And Rob, I think it depends what side of the table you're on, number one, because
Right,
you want to protect your client,
right,
depending on which side you're on.
right.
Number two, we're talking about certified checks and bank drafts and things like that. Couple things to consider. Number one, if nothing's been struck out, the word negotiable has not been struck out.
Mm-hmm.
There's nothing preventing the buyer from delivering a personal check. I don't care what the listing brokerage's policies are. It's what's in the contract and in the APS. That's what counts. So if it doesn't say that that a certified check or a draft is required, then your buyer can drop off a personal check, and the listing brokerage has to accept it. It's not up to them. That's number one. So another point for clarification there, folks, if you're on the listing side, pay attention. And if you want a certified check, put it into the agreement. Okay,
Awesome.
so that's number one. Number two, Nadeem, what happens if the buyer doesn't bring deposit, seller decides to sell somebody else? Is a mutual release necessary? We're going to talk about that in a minute. Okay, so number two, never mind certified checks and bank drafts. As many of you know and practice, things are done, generally speaking, by EFTs these days, or by direct deposits. There is a new clause in web forms. It's DEP Pay 10, and it relates to direct deposits. Okay, so on the direct deposit, so you could say that direct deposit's got to be and you don't always have control over when it's going to be in the listing brokerage's account, but you can at least have some control over when it's initiated by the buyer, and then you can provide a copy of the receipt that the bank gave to the listing brokerage. Say, look, here it is. Please pay attention. Watch out for when it hits your account. Send me a receipt as soon as you get it. Okay, so that's protecting your buyer. Now, let's come back to what happens, though, if the deposit is not brought at all. There's been plenty of case law, and one of the biggest ones that the courts are using as precedent is Tang versus Zhang, or Zhang versus Tang. I'm not sure which it is. This was a BC case, but courts in Ontario are using this quite frequently as a basis for their decisions. And in that case, the deposit, in fact, was delivered, but the deal didn't close. The buyer backed out. So keep this in mind, folks, because what's happening now is that sometimes properties are not appraising, buyers are not necessarily able to get financing, and they can't complete the transaction because they can't get reasonable or normally priced financing. So they can get it if they pay, rates through the roof, which they don't want to do. It's going to be cheaper for them if they do that rather than not close, because what can happen is if they don't complete the transaction, the seller can go after them not only for the deposit that's already been delivered, but also for any damages that if they have to sell the property for less. So the deposit will reduce the amount of, let me back up. I'll give you some examples. So offer A was $1 million, deposit's 100,000. Buyer says I can't or won't close, as the case may be. Seller puts it back on the market, sells it for 1.2. So 200,000 more. Guess what? They still get to keep the 100,000 deposit. They're gonna have to sue for it, but they can do it. So I wouldn't do a mutual lease in that case if you're on the seller side. Yeah, I know it sounds odd, but not only do they get they won the lottery, right? They got 200,000 more, and they got the 100,000 deposit from the previous agreement because they sued for it, which they have the right to do. That's Tang versus Zhang. Now, they sold it originally to buyer A for $1 million, 100,000 deposit. They resold it for 800,000, 200,000 less. Buyer A is responsible for the 200,000 in damages. They've already given 100,000 deposit. That 100,000 goes in reduction of the 200,000 damages. So buyer A now has to come up with an additional 100,000. So it'll total 200. The 100 they already gave as a deposit plus another 100,000. Okay. So Nadeem, coming back to your question as to whether or not a mutual lease is necessary for the seller to put it back on the market, what I'm suggesting is don't sign a mutual lease if you're the seller, because if you do, you lose all your rights to go after the deposit, whether it's been delivered or not. Remember, you can still go after the deposit even if it's not been delivered if you sell it to somebody else and sell it for less. Okay? So I want to caution you that I'm not a lawyer. It's true I play one on television, but I'm not actually a lawyer. This is just through research and through asking lots of questions and speaking to lawyers. So I can tell you that what we're talking about is the case. However, do not do anything without first speaking to your client's lawyer or having your client speak to the lawyer and then get it in writing from them as to what you should do. That's protecting your client. Remember, when you protect your client, you protect yourself. It's not protect yourself first, it's protect your client first. If you do, you are protecting yourself. Okay? So no mutual lease so quickly without speaking to a lawyer first, because you'll be giving up your seller's rights. Now, how do we prevent ourselves from getting into, or our clients from getting into all kinds of trouble if they're on the buyer side? We don't want to make them vulnerable. Well, there's a few different ways to do that. Number one, if your buyer is getting involved in a multiple offer, or even if it's not, it's just one offer, you want to make sure of a couple different things. You want to make sure, first and foremost, that they really love the property. And I always say to my buyers, you know what, guys, I can see the looks on your faces. It seems like you can take it or leave it. If you can take it or leave it, do yourselves a favor, leave it. Let's find something you really, really like. You know, and you guys, you know that you can tell when your buyers really like something. They look at each other and they've got these weird looks on their faces. They don't even have to say anything, you know, because they know. Sometimes it happens even before they step foot in the house. Okay, I'm sure some of you have seen that happen too. So make sure they love it. Number two, make sure that they've got their financing in place. And what that means is more than what you think it means. It doesn't just mean that they got a pre-approval, because pre-approvals don't mean a whole hell of a lot. It's not a commitment. It's not the same thing. You also want to make sure, in addition to the pre-approval, because at least it's something, it's not everything, but at least it's something, that they have a cushion, because if they end up paying 1.2, but the property only appraises for $1,050,000, they're only going to get financing for 80% or whatever it is of $1,050,000. So that extra 150 grand they've got to come up with out of their pockets. Now I just explained to you what could happen if they're not able to come up with that 150 grand and they can't close. They're going to lose their deposit and potentially a lot more. So crucial that you confirm that they've got a cushion in case the property doesn't appraise. And I think it's also important to tell them the property might not appraise. So have that difficult conversation with them. And I would also ensure that I have them sign a Form 127, which is the buyer's acknowledgement that that they're not putting in the following conditions. This form is kind of like, when you see the commercials on American TV for medication, you've got about 15 seconds of the benefits of the medication and about a minute and 45 seconds about all the possible side effects. You're going to go a penis out of your forehead, you're going to have pussy discharge coming out of your right ear, all that kind of stuff. That's kind of what this form is like. And it's important that the buyer completely and fully understands what could happen, because you've explained it fully, what could happen in case they can't close or won't close, as the case may be. So number one, make sure they love it. Number two, make sure they are well financed. And if they don't have the money in their own account, they've got a rich uncle or aunt that they can go and get it from who's willing to give it to them, as the case may be. Okay. And number three, make sure you completely and fully explain to them what could happen if they can't or won't close. If you're on the seller side, don't be in such a rush to have your seller sign a mutual lease. Now, if conditions are not fulfilled, it's a different story. That's, you're gonna sign the mutual lease and get on with your life. But if it's a firm deal, or it's conditional, but the deposit has, if it's conditional and the deposit hasn't been delivered, they're just not going to firm up anyway. So we're really talking about firm deals here. If it's firm, don't be in such a rush to sign a mutual lease without first having spoken to your seller's lawyer and getting their instructions in writing. Okay. So I hope that answers some questions. Rob, Josh, do we have any more?
There's one that came in on my cell phone. I'm not sure if I quite understand it. What is available to a buyer who is waiting on legal registration on title? For example, certificate of pending litigation, city registrations for permits, etc. Do you understand what they're asking? I'm trying
Well,
to.
a certificate of pending litigation could that could be brought on by anybody. That could be I don't know, a common law spouse who didn't know that the property was being put up for sale, and although they don't have any possessory rights and they don't have to sign the agreement of purchase and sale, if it's common law, they do in a match. That's not a matrimonial home, by the way. Common law spouses, that's a whole separate issue. That's not a matrimonial home. Matrimonial home is for legally married, which means marriage certificate. If there's no marriage certificate, it isn't a matrimonial home. The non-owner common law spouse doesn't have to sign the APS, but they may be entitled to some monetary compensation there. So they could end up with money. They just don't get possession. They don't have to sign the agreement. So if they find out later on that the property's been sold and they're not going to get any money, they could slap a certificate of pending litigation on there, and that could hold up the closing when the property is sold. So I just saw some clarification. They're waiting for it to be cleared. They're waiting for the title to be cleared. Well, Zaid, I'm not sure that this is really a legal issue, but just so we're clear, if there's a certificate of pending litigation, the deal's not going to close until that's been dealt with, whatever that is. Okay.
Very good.
And remember also that you've got a title search clause in your APS, and maybe another time we can do an explanation on that title search clause, because I think we'd be hard pressed to find anybody here or anywhere else who actually gets what the hell that clause means. So we can get into that at some point too, if you want, but that's another story. That's another problem for another time. So do we have anything else?
That was amazing, Mark. I think we went well above of the topic of not getting a deposit on a firm offer, but people were engaging and my texts were going, so that's a good thing. I hope we can do this again with you, and I'm sure we will. just before we do leave, just tell me a little bit about this Ask Mark thing that you're doing.
Well, thanks for asking, Rob. It's I've been at this now since 1994. It's going to be 28 years in March. I started when I was 4, and I've been, in that time, just because you start accumulating lots of knowledge, particularly folks that, advise everybody, read lots of stuff, because the more you can make yourself stand out from the rest of the schleppers out there, really what you've got to offer is knowledge and expertise. So the more of it you can provide, the better off you're going to be, and the more you're going to be able to help your clients, and the more they're going to be attracted to you. So learn whatever you can. And read whatever you can. Make sure the sources are, of course, credible. Which who knows these days that that's hard to discern. But in any event, because I've been at this for so long, and because I was an AREA instructor and a Humber instructor and broker of record, and and on these committees, you just acquire a lot of knowledge. And over the years, I've had people call me, whether they're from my brokerage or not, just to ask me all kinds of questions. And so I decided, I figured maybe there's a gap, because I know sometimes your broker of record or manager is busy or doesn't get back to you as quickly as you would need or you would like. And you want a source that you can go to that you can trust for some good advice and information. So I've started this up. It's ask-mark.ca. On there, I've got about, 35 videos or so and some blogs, which you've got access to anytime you need. And if you want access to me, then of course we can arrange for that too. So that's what Ask Mark Consulting is. And I just love doing things like this and helping agents grow as agents and help them grow their business just through the knowledge and expertise.
Thank you. Well, you know what? It's been a great addition having you back in the office and seeing you and asking you these questions. And I figured it would be a good topic to talk about. So, you did a great job, and thanks for everything that you do. And if anybody has any questions, they can email us or, just contact myself or Mark, and we can help you out with that.
And if anybody has any ideas for some more of these, please just send them our way, and we'd be happy to accommodate. All right. Thanks for joining, guys. Really appreciate it.
All right. Thanks, Mark. Thanks, everyone.